So, welcome to the 5 Games for Doomsday YouTube channel. I'm entering the world of investigative journalism here, and I have a very special guest all the way from the 5 Games for Doomsday Discord, also New Zealand, a proper lawyer, someone who's far cleverer than I will ever be, Colin David Hunter. Welcome to the channel.
A pleasure to be here, Ben. I'm not really convinced I'm the smart one here, but I am the person with lawyer as a profession, so that gives me a little bit of qualification.
Yeah, so we're here to discuss the Upper Deck Ravensburger lawsuit regarding the Disney game Lorcana. And before we get into that, can you give the viewers and listeners a précis of who you are, what your qualifications are to speak on this?
So I'm a lawyer for a firm in Auckland, New Zealand called Hesketh Henry. I'm an associate there. My specialty is in largely actually insurance litigation and in particular maritime laws, but also includes trade law. And I deal a lot with cross-border disputes. So that may be slightly out of the realm here where it's a Californian law issue. But there are some really interesting contractual issues. And obviously I should premise everything I say by the fact that it may well be that a Californian lawyer will say this guy doesn't know anything, but hopefully the kind of general conceptual issues are the same. I'm willing to at least say things here and look like a fool. So hopefully I won't be, but I'm always open to correction from people more knowledgeable.
And so, as a bit of context for us all who know nothing about the law, really, how specific, how nuanced, how arcane is this area of law that's being prosecuted in this case?
It is actually more general than you might expect. It's been kind of pitched in the board game media as a kind of intellectual property dispute, which is probably strictly true, but most of this is actually just a general contractual dispute, and with some what we would call equitable causes of action. So basically, kind of allegations of people acting in bad faith and breaching various duties associated with that. And there's also some negligence thrown in there for good measure. If you get into the theory of what's going on here, it can be quite arcane because we're going to be dealing with intangible property and what that means and whether we can possess such things and are they real and do they affect third parties and things like that. But quintessentially, the main thing here is really a breach of contract claim and then a claim against the designer's subsequent employer, Ravensburger, to try and shoehorn them in as well. So, and that's probably where the money is. That's the solvent party will be the Ravensburger, obviously.
So, reading the filing, I was interested to see that the case is being prosecuted in Nevada, not California, where both of the companies are based. Would you have any idea why they're filing in Nevada as opposed to California?
So I'm going to correct you there a little bit.
Please do at any time.
So it is before the Californian court in San Diego, but you have picked up on a really important point, which is that Upper Deck is a Nevada company. So what you've got here is you've got Upper Deck based in Nevada. You have, sorry, I say that. Upper Deck, I made notes of this. Upper Deck is, I believe, based, in Nevada, but they operate mainly in California. Sorry about that, Ben.
No problem.
In California. But they entered into an agreement with Ryan Miller that has what's called a jurisdiction clause. And that's a clause in a contract where you promise to resolve disputes in a particular jurisdiction. And in this case, that was in San Diego, California. So and also the contract was governed by Californian law. The interesting thing here from that point of view is why Ravensburger has to be in a Californian suit. But we will, the answer is going to be because the other parties have to be in California. So it's probably easiest to shoehorn them in as well. But we will avoid the niceties of conflict of laws too much, even though that's a particular area of interest for me. But yeah, that's why you have this weird thing where nobody's living in California, but that's where it's being heard.
So can you give us then, before we sort of dig into the meat of it, an overview, a sort of bird's eye view of the case that Upper Deck are bringing against Ravensburger and Ryan Miller?
Yeah. So from a kind of high level point of view, what they're doing is they're basically saying, we had a contract. It all kind of stems out of this. We had a contract with Ryan Miller. We hired him. And in that contract were basically two general obligations. One was this idea that he wouldn't steal our property, query what that means and what sort of property. And the second thing is that he signed a non-disclosure agreement or agreed not to tell other people confidential things. And that Ryan Miller basically breached those obligations when he went over to Ravensburger. And by doing that, they then get entangled with this bad faith or this equitable issue where they knew that he was doing bad stuff, and therefore they are also tainted, and therefore they're asking the court to take steps. Now, that is a gross simplification. There are a bunch of other causes of action, but I think at a high level, that's the center of the dispute. So it's one party breaching a contract and another party being alleged to have known or to have participated in this bad thing, and therefore they should be affected as well.
So the center of this case seems to center around a meeting that was had, a summit, a game design summit that was had between Upper Deck and Ryan Miller, in which they discussed this game and they bandied around ideas, and Ryan Miller signed a contract saying that he would not disclose anything that was discussed at this meeting. Can you expand on that for me?
Yeah, that's right. So there's a meeting in I think it's the end of it's in the end of 2018, where they have a summit. They invite a bunch of game designers, and they're basically looking for feedback on ideas and new ideas. And as part of that summit, the Ryan Miller and other game designers basically signed a contract. And what they're alleging is that in that contract, there were clauses that said that Upper Deck owned all property that comes out of that, intellectual property, but also intangible property or anything that comes out of that. And also that it was any material there was confidential. So they couldn't disclose that to third parties. And then out of that meeting, I guess they were impressed with Ryan Miller. They then entered into a work for hire agreement. And that agreement, evidently, according to the complaint, has the same sorts of terms in it. And so then when he worked there for another year and a half, all the property and all the material was confidential and therefore couldn't be disclosed and couldn't be passed on. So that's the kind of factual basis. We should say at this point that what we're reading, and it is, if you want to look at it, it's freely available online, the complaint. This is one side of the story. They're saying this is all the things that we are going to prove, but they don't have any evidence that this is true currently. But that's why they will go to trial, or that's why they'll present evidence, and whether they can is going to be the substance of the legal part of the legal battle.
And so let's go through these causes of complaint then, from the top. So there are some that target Ryan Miller specifically, some that target Ravensburger specifically, and let's go through. They're called causes of action. You can see I'm absolutely massively knowledgeable about the law here. And so the first one is breach of contract. Can you give us an overview of what the first cause of action is?
So I think when I hadn't read any of this, it struck me that this must be the core of what it was going to be. And basically, the allegation is that Ryan Miller breached his contract, again, by doing one of two things, either disclosing confidential information or giving away property that Upper Deck owned. And it's that question there that is the real nub and kind of complexity here, because the issue is what constitutes property here. We aren't talking about a car, a game box. We aren't even talking about a piece of art. What is really being alleged here, and you can read it here, it says products, works, concepts, trade secrets, and intellectual property developed by Upper Deck. So what this means is the concepts and game, and it includes these kind of game mechanics. So in terms of understanding this, there's a concept that's really helpful to understand about the nature of what property is. So at law, what separates kind of property in some ways is the fact that property can affect third parties. So Ben and I can have a contract and we can agree to pretty much anything. I can't sell myself into slavery, maybe. There are a few things that we can't promise to do, illegal things. But in general, we can promise to do pretty much anything as between us. But the central element here is whether that affects someone else. And in that case, it's Ravensburger. And that's why this property issue is so big. So when we talk about, it's kind of commonly known you can't copyright a game mechanic, and that's because a copyright affects a publication or something like that, whereas a game mechanic is a concept. So you can copyright your rules, you can copyright the wording, but you can't copyright the concept of a thing, right? And I think that stands to reason. Otherwise, we couldn't even think about things, right? It's patents that actually do that, and it's very difficult to get patents on game mechanics because they have to be truly novel, and you have to meet a lot of stringent requirements that intellectual property lawyers will be far more qualified than I am to talk about specifically. But the gist of it is it's difficult to get a patent. So one of the things in understanding this is that what we're dealing with here are property rights that are intangible, that we can't grab hold of, that may or may not really exist. So they can exist in a contractual sense between parties, but the question is whether they are the sorts of things that attract the potential for liability from a third party. So whether Ravensburger can be liable as a third party for kind of dealing with these concepts. And again, I'm not a Californian lawyer and I'm not an expert, but that is a very knotty and difficult legal question from a conceptual point of view. And actually, if you look internationally with the rise of electronic trading and things like that, different courts have come to different conclusions about the sorts of properties that can exist in these kind of nebulous sorts of rights. And if you really go back, there is a great history of this. There's a thing called choses in action, which is an ancient term, but refers basically to something that you can enforce by suing in court, a contractual right. Those can be bought and sold like property and things like that. So there is precedent for this, but I think the question's going to be about the nature of these rights and whether Ravensburger really can be liable for dealing in a concept, right?
So the second cause of action then is, and I'm reading this from my phone for the listeners and viewers, breach of fiduciary duty. And I guess, is this the one that's saying because, according to Upper Deck, he gave away the mechanisms for their game Rise of Icor, that he is harming them financially?
Yeah. So breach of fiduciary duty, it's a funny word, this fiduciary word. What it really means is that you had a special obligation that arose from a relationship of trust, is the best way to think about it. So, for example, when you act as, you know, on behalf of somebody else, they give you some money to go purchase something from the shop, you owe a duty with respect to that money to purchase it for the reasons that they gave it to you. For example, you can't use it to buy your own stuff. I don't know if that's the best fiduciary example, but the point is that they have to do with obligations that do with trust. So when you are employed by someone as an employee as opposed to a contractor, you owe a fiduciary duty. So the whole thing behind employment law historically, and in the US it's a little different, but in other common law countries and other places, an employee owes fiduciary duties that a contractor does not, i.e., they have to look after the best interests of the people that employed them. And so, what this cause of action is saying is that Ryan Miller, as an employee, owed duties to tell them about his plans to steal, to quote unquote, in their words, steal stuff, negotiate with Ravensburger, go over to them, and all that sort of stuff. The issue with this, of course, is whether he was an employee at the time that they negotiated, whether really that caused any loss, whether there really was any stealing, whether these are things that are capable of even really being stolen. I mean, trade secrets definitely can be. So if it was a particularly secret, special thing, then potentially, again, that can come through. But really, this is just another way to try and allege dishonesty or bad faith on behalf of Miller, and therefore potentially to try and sheet it home to Ravensburger.
And there are a couple of things in this that seem to me, as the layperson, a bit he said, she said. And this third cause of action, where they accuse Ryan Miller of fraud, seems to be that, in which they assert that 2 years before he stopped working with Upper Deck, he was working with Ravensburger. Now, how would you prove that? I mean, if Ryan Miller just simply says, "No, I wasn't," how can you bring that before a court and make it compelling for the jury trial that they've demanded?
Well, in my own jurisdiction in New Zealand, you would struggle because you can't plead things like fraud without a reasonable basis to do so already, and probably you'd struggle. I'm not sure about California, but it looks like maybe the rules aren't as stringent. So the reason you do that is there's a process called discovery, and discovery is basically where both sides go through all their documents, including emails, everything else, and they search for things that help them, but also that can hurt them, and they're legally obligated to turn those over. And because lawyers go through them, they have a professional obligation to the court. So they would have to, if they came across something that hurt their client's case, they're basically legally obligated to provide it. And if they don't do that, they can suffer disciplinary action, be struck off. It's pretty serious. So what you'll find is that they'll go through their emails and they'll find a bunch of old emails, potentially between Ravensburger and Miller, that has them discuss this. And maybe those emails show that they intended to defraud Upper Deck. I mean, my guess is probably not, but you never know. I think it's a bit of a fishing expedition, but by putting this cause of action in there, you are forcing them to disclose that when discovery comes, if there's anything there. That's why, like I said, in our jurisdiction, you're not allowed to put it in unless you have some proof. But if it's a little looser, then you may well be able to do it. It's also the case that there's a civil code provision here that I did actually take a look at, that they're relying on. that has to do with that has to do with it has to do with the remedies that they can get. And one of the remedies they're looking for here is an injunction. So one of the reasons they're pleading this, or they're talking about fraud, is that one of the remedies under the Californian statute is that the court's entitled to give an order, and that order could be almost anything, including preventing Lorcana from being distributed and sold, which would obviously be a king hit, right? Because it would destroy, their competitor's product. Now, whether they're likely to get that is another matter, but this gives them a route to doing it. So,
And so the fourth course of action then is essentially the same, but the other way round. It's asserting that Ravensburger induced Ryan Miller to break his contract with Upper Deck and to take what he'd researched to them. Again, I guess this is a similar thing, right? I mean, it seems very he said, she said to me.
Again, it'd have to come out in discovery. And what you'd get, and look, I can say as somebody that's undertaken discovery and gotten things, and things come up, and you do get things that give you a bit of a king hit sometimes. It's not that common, but it does happen. And because they have to be disclosed, you might be able to prove that they had emails, or that they had, or there was a record of a phone conversation and someone took a note of it, or there's all kinds of things that could be out there that they might be able to prove that. This particular cause of action is what we call a tortious cause of action. So again, this is all about trying to make a third party to a contract liable. And one of the things you're not allowed to do generally is encourage somebody to break their contract in order to cause harm to that other party. But normally you have to do it in bad faith. So you have to have intentionally done it and encouraged it in order to cause the other person harm. And it's not always very easy to establish. It may be in California that it's easier, because I note that in their pleadings, it appears to have a negligent standard, which is a little lower than a kind of bad faith standard. And again, a Californian lawyer would know much more about the specifics of that. But that's effectively what they're doing. And again, it's about bringing in the solvent third party, Ravensburger, into the proceeding so that they can recover, I suspect, against them. Because probably Ryan Miller, as a game designer, is not sitting on millions of dollars of cash.
And so the fifth cause of action then is entitled Negligent Interference with Prospective Economic Relations. And again, from my very, very layperson point of view, it seems to me that what they're trying to say here is that Ravensburger should have known Ryan Miller had a contract, and therefore their approach to him was legally negligent. Is that it?
That is it. This is a weird one for me from a New Zealand, England kind of ordinary common law point of view, because ordinarily one is allowed to negligently affect a third party in terms of the economic loss they suffer. So normally I'm not allowed to destroy your car, but I can cause you loss in the market, what lawyers would call pure economic loss. So this may be, again, I don't know a ton about it, but it is a sort of negligent. It looks to be a negligent cause of action. So they're basically saying you negligently did something that made us lose money. And the key question here, I suspect, and again, not a Californian lawyer, but will be whether Ravensburger really owed Upper Deck a duty of care here, which means, do they have a legal reason that they're supposed to look after their competitor? And maybe they do in particular situations, such as that they know particular things. Maybe that's how this works. I don't know the specifics on this one, but it is, from reading the pleadings, basically a negligence allegation. But normally the negligence suits turn on whether that particular person owes a duty to prevent that loss, especially when it's basically an economic loss and not damage to physical property.
And the sixth course of action then is constructive trust, and this is both against Miller and Ravensburger. Can you give us an overview of what that is?
Yeah. So a constructive trust is what people describe as a remedy, but it's often pleaded as a cause of action. Basically, what a constructive trust is in situations where you have knowledge of acting badly. So think a kind of old school idea about morality, that you're only doing a bad thing if you know that it's bad, right? Your conscience is tainted. So in certain situations where your conscience is tainted, the law says you have this thing, but you are holding it on trust from the person that you took it from. Right? So imagine, Ben, you stole a painting from me and then you gave it to Stephen, right? I could say to you, give me my painting back. And you say, look, I gave it away. I don't have it. I don't have any assets. So tough luck. But the law would say, well, you were holding it on trust for me because you had no legal reason to take it from me. And Stephen, because he got given it and didn't pay money for it, is also holding it on trust because the courts will prefer my claim over Stephen's claim to have been given a thing that was stolen, basically. So that's the essence of constructive trust. So here, again, we have to deal with these kind of nebulous concepts. And the question is, again, whether these concepts are capable of, in a proprietary sense, of being transferred. Because one of the things about concepts is you're not denying the existence of them to the person you took them from, right? I mean, Upper Deck still has the concept. It still has that. So the question is whether there could be a constructive trust of this sort of thing. And again, that goes back to our initial question. What are the sorts of things where intangible property can affect the rights of third parties? And the third party here being Ravensburger.
And so the seventh course of action then, it really sounds, these legal documents kind of sound to me like a sort of biblical chapter. The seventh course of action. And this is conversion. And it seems to me that this is the one that says that Ravensburger and Ryan Miller consciously took the property of Upper Deck and converted it into a game for Ravensburger. Am I right there?
Yeah, that's right. Conversion is a tortious cause of action that normally comes out of taking possession of someone's property. Normally, this is not really available to the sorts of proprietary claims that are being made here, because normally what it means is that I take possession of something so that you don't have it. And so normally it only applies to kind of physical things, or when they're intangible, they have to kind of be unique in the sense of I can take it from you. So maybe like a Bitcoin, or, maybe I could convert, maybe I could possess that. But there's this hard concept in law about what is capable of possession. And to give you an idea, the UK Supreme Court in the last few years found that electronic versions of things, as an example, were not capable of possession and therefore could probably not be converted. Different courts have gone different ways on that. There's a lot of legal theory around that. But for example, it's meant that the UK is now passing an Electronic Transactions Act in order to basically solve this problem. But the point is, there's a hard conceptual issue. Again, a Californian lawyer, maybe they've sorted out the law there. In New Zealand, it looks to be sorted out, but it can go either way, and it's not an easy issue.
And the eighth course of action then is unfair competition, and this is the one that asserts that Ravensburger took their game and then unfairly marketed their game under a different banner, and so didn't give Upper Deck the equal opportunity in the market to market their product because Ravensburger gazumped them on it, right? Is that,
yeah, that's right.
Is that correct?
That's right. I mean, this is one, again, it's hard for me to have a lot of understanding of exactly what the sorts of legal tests are. This arises specifically out of a Californian statute, which I have looked at. But the definition of unfair trade practices and things like that, we have kind of equivalents in New Zealand, but I don't really know the extent to which those are the same and what constitutes kind of unfair or misleading or something that would give rise to that particular cause of action. So it's a little bit hard to tell what is actually being alleged there, other than general unfairness. Presumably, there's more than that, but again, I think that would be interesting to see where it is. And again, when you make these things, you often throw absolutely everything in that you can think of, because it's better to have everything there than forget something and then try to amend your stuff later. So it's kind of a tactic to put in everything. And it, this feels a little bit like a kitchen sink. And again, it's to deal with Ravensburger. That must be their kind of main aim in this thing, because they're the deep pockets.
And so at the bottom, now this is just a question for my curiosity. I often notice the dramatic, and at the bottom of the document it says, demand for a jury trial. Upper Deck demands a trial by jury on all issues so triable. Is that just something that always goes on the bottom of a legal document? Because it sounds to me like they're going, we demand our day in court.
Yes, I mean, the use of demand there is a little overly dramatic, but I think the reason, the issue here is that the U.S. allows jury trials for a broad number of causes of action. Most jurisdictions would not allow a jury trial on a civil action that wasn't for defamation. So normally a judge would decide this. And I suspect that one of the advantages of having a jury is that you probably have a little more uncertainty on the outcome, because as lawyers, you kind of get a sense of how judges would react. And so if you're a plaintiff that has a lot of speculative causes of action, a jury trial is probably a good idea, I guess. Again, American lawyers will be able to tell you better, but that would be my guess. If I'm a plaintiff, it's probably a little bit better in terms of making the other side a bit scared. And again, it may be that there's a want to settle this behind the scenes, get a bit of a payout. It's hard to know the strategies at this stage, but that's always that's always a question. With these sorts of things.
So the reason we're talking is because I'm not the kind of person who hangs around with lawyers particularly, but I do hang around with gamers, and you're a gamer. And what's fascinating reading the filing to the court is they have a description of both games in there, and I was struck by how similar Lorcana is to. Remind me of the name of their game. Something of Icor.
Icor, yeah.
I was struck by how similar those two games were, but I was also struck at how similar the Upper Deck game is to every other collectible card game there on the market. You build up mana, you attack, and the only fundamental difference is instead of whittling, I mean, it even uses 20 life points, right? But instead of whittling your opponent down to 0, you buff yourself up to 0. So as a gamer, I mean, surely you must be thinking that Upper Deck are taking the piss, right?
To some degree, yes. I think that's right. The game is so similar to a million other CCGs and TCGs, right? It isn't that different. It uses resources to summon cards. You put the cards, the cards are kind of multi-use. Yes, I mean, this is part of what I think revolts a lot of gamers seeing this, is they're like, well, this is just the same as every game, lots of game steal concepts, et cetera, et cetera. And I think that's right. I mean, I think that's a weakness in their case from a legal perspective as well. But I think it's worth noting that the people that are going to be making findings about facts, so one of the things is going to be a jury. They're not going to be experts in gaming. In fact, so that's an issue. It's going to be so the question is whether those plaintiff lawyers can convince lay people. And you'll see this issue arise a lot in copyright cases with regard to music and musicians. I was a musician before I was a lawyer. And, my musician friends go spare when they're like, this sounds like that because it's got the same chords or whatever it happens to be. But you see, but again, it's about what a kind of reasonable person, in this case, a jury member, would think, not really what experts or people that are involved in the hobby would think. But I do think there is an element here that they may struggle with. So I think the claim for breach of contract is going to be strongest when it involves a trade secret, or involves information that is definitely confidential. And I guess one of the questions here is whether any of these concepts are really that confidential. There is an allegation that Ryan Miller copied the text from the cards. That might be a breach of copyright, although they don't allege it. But you'll see here that none of the causes of action are breach of copyright or breach of or breach of anything else, or of a patent. And you can actually see in the pleadings that it looks to me, reading between the lines, that Upper Deck filed for a patent, but only after it read the publicly available rulebook for Lorcana. It doesn't say that exactly, but they filed in April, and that's when the rulebook for Lorcana was publicly released. So it looks to me they saw the rulebook for Lorcana and then decided to issue a patent. A patent attorney will be able to tell you whether they might be able to get it or not. I think the general consensus is it's unlikely. But you can see that there's this kind of issue with the originality of any of this. Is this really a trade secret? Because every CCG, is this confidential information? So if he's not copying the words in the rule book or the art or something like that, what is the loss here? And again, it's about much more than just Ryan and Upper Deck. I think it's really about how can they get to Ravensburger, their competitor. They probably don't care that much about Ryan directly. I'm guessing he's not living it up in Beverly Hills. Yeah.
And so looking at the filing then, and again, we stress you're not a California lawyer. This is not your specific area of expertise. But how strong do you see their case as being?
Well, it depends if they can. This is the lawyer answer. It depends if they can prove everything that's in their filing. I mean, if they can prove that there's bad faith and things like that, I mean, a court will take a dim view. If what happens is Ravensburger conspired with Ryan Miller to defraud Upper Deck, then the court is going to look pretty bad, right? But I think the thing that's in the back of my mind is when you read this stuff is like, are they really going to be able to prove that? Is the most likely explanation that they kind of conspired and acted in bad faith? Or is it that he kind of got bored of Rush of Icor? The Disney tie-in for Ravensburger was interesting, and he was like, let's go over there, and probably didn't think about it too much. And Ravensburger probably didn't think that much about it, maybe. And how much they have to look at whether there's particular clauses, is a good question. I mean, ultimately for me, if Upper Deck really wanted to protect themselves, you think they would have included a restraint of trade, i.e. something to prevent. I guess Ryan probably wouldn't have agreed to that, but that's the sort of clause that would have provided a lot more protection, I would have thought, than trying to shoehorn other things in. But I guess we'll see. It'll be interesting to read the defense once that comes out. because we don't have the other side of the story from either party.
And so, say Upper Deck win or Upper Deck lose, what are the potential ramifications then in the future? I mean, if Upper Deck win, is that a sort of thin end of the wedge when it comes to being able to copyright game mechanisms? And could that affect people's ability to create games in the future?
Honestly, I actually don't think so. I think what it will do is it might mean that people are more careful with their contracts. I mean, if they win, the reason that they're going to win is because there's been a breach of contract, and Ravensburger did something to kind of inflame the situation such that they became liable, whether that was through acting in bad faith, or that was through kind of encouraging a breach of contract, or that was through some other mechanism. It's going to be a situation, I think, where that's happened. You know, these things aren't copyrightable. There are patents, but they're rarely given for games. So my general feeling is that probably this is very specific to this breach of contract charge. And yes, it means if you're a game designer and you sign up to these sorts of things, you know, hopefully a lawyer can look at it or something like that. But I think it's much more about that than about the intellectual property issue to do with copyrights or anything else. I think that's actually largely unchanged. It's just that between Ryan Miller and Upper Deck, you can agree to pretty much anything. So theoretically, you can agree to never say a word, right? Like, you know, Ben and I could have a contract where Ben's not allowed to say bell end, for example.
I'd break that in the first 5 minutes.
You know, I'm not sure what damages you would have to pay, but the point is that, you know, we can agree to anything between us. The question is really about whether it affects other people. And normal intellectual property rights like copyright and patents they can affect anybody in the world, well, in a jurisdiction, whereas an agreement between you and I won't necessarily have enough special effect against anyone else unless there's a special thing that makes it happen. And usually that's bad faith or interference in a contract. That's what they're pleading, right? And so it's really about those breaches of contract, you know, about whether it was confidential information or whether it was, you know, a property that could be passed or whether it was a trade secret. Those are things that might be able to be protected. And if Ravensburger was kind of incompetent enough / acted in bad faith or turned a blind eye, maybe they can get caught. But again, proving that is difficult. You know, but if there's a smoking gun email, you never know. Yeah.
Brilliant. Well, Colin David Hunter, hotshot lawyer all the way from Auckland. Thank you very much for your time.
A pleasure. Thanks so much, Ben.